advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Well, welcome back. Carl Rominger here. Steve, you had a question about what happens if you don't have car insurance?
Well, if you just get behind on the bill, is there like a law that
you must carry insurance in order to drive the car? Yes. If you get caught driving without insurance, you will lose your license.
No, but what I mean is, if is there a certain amount? Is that part of the policy, or like say if one time I misplaced a bill and it got shuffled under papers, and I'm like 3 weeks behind, and next thing I know, I'm getting notices. And a girl at work said she had all kind of troubles with. They took her tags and were going to take her driver's license.
Mm-hmm. That's what I mean. You got to have your insurance paid up, or you can't drive the car.
Uh-huh.
So if you drive at a period you don't have insurance, you can lose your driver's license.
Yeah, well, I knew that. I was just wondering if there's like a grace period that the state gives, or it's all up to the insurance.
It's up to your insurance company gives you a grace period from cancellation. So you'll get a notice that says you're behind, and here's your effective termination date on your thing. And if you don't get us money by this date, your insurance is over.
Yeah,
and there's no grace on that dead period. Once the insurance is canceled, and that cancellation date and time, like 12:01 a.m. on whatever day, then going forward, you have no insurance.
Yeah.
All right?
All right. Thanks, Carl.
All right, boss. 540-0580, Carl Rominger answering your questions. Diane, how are you?
Did you say Diane?
I did.
Hi, Carl. I'm probably one of those people in the minority who actually want to be called for jury duty.
Okay.
However, I'm 56. I've only gotten 2 notices in my life, and both times I did not have to report. So I was just wondering, is there what is it actually do they do to determine whether you're going to be called or not?
Well, to determine whether you're going to be called or not, they basically just pick a lottery system based on a list of registered voters and supplemented by driver's license lists and things like that. And they just at random pick people off of it and send them a notice. So we've had people tell us that they've been picked for a jury, or at least been summoned for a jury 5 times in 10 years. We've had other people tell us that they're 87 and never been asked.
Okay, I guess that's why I never win anything in the lottery, too.
Right.
Well, okay, so is there any way you can, if you want to serve, does that not do anything for your chances?
No, we don't. And, the answer is we don't have volunteers. And frankly, the lawyers probably wouldn't let you on if they discovered you volunteered for jury duty.
Oh.
Because everybody would want to know why you want to be on a jury, and then that creates a variable that we can't control for, so we want to get rid of you.
Okay, so then in other words, if I ever do get called, I shouldn't let them know that I want to be there.
I'm not saying that either.
Oh.
What I'm saying is the fact that somebody would take the time to volunteer and go and show up and sign up to be on it would be unusual. Therefore, but half the people want to be there and half the people don't want to be there once they're summoned.
Okay.
I'm just saying that created a little situation. If I discovered that I had a juror, who's a little overly anxious to be on a jury, the question would be, somebody might go, here's the different way you could logically think about this. Her grandfather was wrongfully convicted of a crime, and if I'm the district attorney, I'm thinking, oh man, she just wants to get on a jury so she can upset the apple cart in the criminal justice system. In the meantime, the defense lawyer is going to be thinking, maybe she was molested as a kid and just wants to make sure that somebody goes to jail. Maybe I shouldn't have her. You know what I mean?
Okay.
So the lawyer's brains will go crazy with speculation about why you should or shouldn't be on the jury, wondering why you wanted to be, right?
Okay.
Just forget the fact that you just thought it would be interesting or you wanted to do your patriotic duty. We would never actually come down on that side of the fence.
Okay.
Or if it was true, because we couldn't exclude the other possibilities, everybody would say, I don't know.
Okay, all right. So I'm fascinated by true crime. Those are the books I read. So
right.
That's pretty much why I'm hoping to like get called for a major
right. Well, of course.
case.
Of course. So really, you just want to live out your true crime fantasy. I got it.
Yeah, exactly. So it's not going to happen. That's what you're telling me.
Right, yeah. The only other way to live out a true crime fantasy is to probably hang out in seedy locations late at night and hope a serial killer comes by, but that doesn't sound like nearly as much fun.
Okay, well, thanks, Carl.
All right.
All right, bye.
Oh, no. True crime fantasies. Probably reads Detective Magazine, has all the Ann Rule books ready to go. Nothing wrong with that, though. Actually, a lot of the true crime stuff is very interesting because it's probably more fascinating than some of the fiction. If you haven't read an Ann Rule book, I recommend you start with her first, A Stranger Among Us. Very interesting. You know, she actually was a volunteer at a rape crisis clinic where, lo and behold, there was a serial killer, and I won't tell you which one. You'll have to look it up. There was a serial killer working there with her who also happened to be a probation officer at one point. And that's before he went, completely crazy and on his little romp around the countryside, so to speak. 540-0580. If you're just joining us, of course, want to remind you guys, pay attention this week. Supreme Court's going to come out with some major cases. They only have, they're done here in June. And we have some really big whoppers floating around out there, including what's going to happen with Proposition 8 and what's going to happen with the Defense of Marriage Act, and also what's going to happen with affirmative action. So there are 3 whoppingly big cases to be decided by the U.S. Supreme Court this spring. Again, watch for John Roberts to come down on sides that I think some of you conservatives would not have guessed when you picked him and supported him and ran around and thought he was the greatest thing since sliced bread, because he is a conservative in many respects, but he's a conservative jurist in many respects, and that's very different than a Republican or a Democrat. And, of course, also remember that the history of the Supreme Court is replete with examples of presidents appointing somebody who then turn out to have a completely different political stripe, or at least seemingly different political stripe than anybody would have thought they had at the time they were appointed. I think being on the court and being appointed for life and knowing that nobody can remove you but for an impeachment hearing and your ability to pretty much judge things the way you want lends new freedom, and people tend to go in directions that they might not have been anticipated earlier on. So it'll be interesting to see how they decide. I think on the affirmative action, it's probably time to get rid of affirmative action, absolutely. I mean, you can only have it for so long. And originally the courts had suggested that affirmative action could exist still, but that it should be fading with time. And now time has passed, and they've retaken another case. So we'll see what they do there. On the Defense of Marriage Act and the Proposition 8 case, I have a feeling they're going to strike down Proposition 8 and say that California has gay marriage because they've extended it and they can't take it back. The big question will be whether they decide a more sweeping ruling than that. And under the Defense of Marriage Act, I think they're going to say that the federal government cannot discriminate and that they have to follow the state leads on what the states want to do, which would be interesting because if they say that and then they say that, of course, none of the states can discriminate, then effectively they would open gay marriage up entirely. I have a feeling they're not going to write the broad rules quite that broadly, but we'll see. We'll see what they do. So watch, because I told Shane we're going to keep our finger on the button here. And when the Supreme Court rules on these cases, I'm going to have my diatribe ready to go, and I'll post something online as quickly as possible so you can hear my interpretation on it and what it is I think it really means, although I'm sure the rest of the world will be spoon-feeding it anyhow. And I know a lot of you listen to MSNBC, so you'll be able to get your take on what it means there as well. All right, 540-0580. I want to get back from the break. I'm going to talk to John about jury nullification. Yeah, the true crime aficionado called in to remind me. It's The Stranger Beside Me by Ann Rule. And, all right, I'll tell you who it is. It's Ted Bundy. So, before he was... Well, here's the theory. Everybody's, you'll recognize a monster. You'll recognize him. Hey, I watched the Naked Gun sequels, 33 1/3, 2.5, whatever. I thought OJ seemed like a fine guy. So, you're not always going to know the monsters when they're out there. That's just the way it is. Oh, and our jury nullification guy dropped off the line. Well, that's the guy must have got scared. 540-0580 if you want to get on the air here and talk about a legal question The other fellow wanted to talk about jury nullification. I know what he wanted to talk about, but I've talked about this before. It's the historical right of jurors to decide the law and the facts. And so even our first Supreme Court Chief Justice, told the jurors, you can decide whether the law is just as applied in this situation, and that while they should generally try to follow the laws given by the court, they ultimately had the right to nullify it, to decide whether or not the law as applied was just. Then in the 1800s, they went ahead and said, well, you don't have to tell juries about their power of nullification of the law. So what courts did was just simply say, no, we don't have to tell you. And then lawyers, you lawyers may not argue it. You may not tell anybody about it. So you have this magical power, this secret power as a juror that no judge will admit you have. Because that case didn't abolish it. It simply said jurors need not be told about it. So a very interesting question is, what happens when a juror sends out a question and says, Dear Judge, we would like to know, do we still have the historical power of nullification? And could you define nullification for us? And what would happen to us if we chose to exercise the historical power of nullification? Question mark. If I was the jury foreman in any jury, that's something I would send out just for fun, but that's why they'll never let me on a jury. But, if somebody was in a marijuana trial and they said, this is silly, I don't understand why they're beating up on some guy for growing 3 marijuana plants in his backyard, and while, yes, the judge told me it's manufacture and it's illegal, I choose not to vote guilty in this case. I don't feel it's illegal. Then if you ask that question, it would be interesting to see what the court said and whether the court told you the truth or not. Now, I wonder, would the court take the position that the NSA head took recently in front of Congress, where he said, and by the way, if you want to jump in the conversation, it's 540-0580. Get your legal questions answered, whatever you want to talk about. Family law, criminal law, personal injury, whatever. But would the judge take the position that the head of the NSA did, which is, well, I didn't want to lie, but, I couldn't give up for security reasons the truth, so I just tried to say something that was the least untruthful possible. And so, for some reason, Congress, who's supposed to have oversight over the administrative branch, can expect a false or untrue answer in a hearing, at least according to the administrative branch, because it's the least untrue answer. So, would the judge tell you about nullification, or would he give you an untrue answer or the least untrue answer to mislead you about nullification? I don't know. I do not know. Now, I do know, by the way, when I go to certain courthouses, the prosecutors complain about me even mentioning nullification. And I've actually had a prosecutor try to tell me that as an officer of the court, I shouldn't even be telling you people about nullification. Can you imagine that? And I said, well, my First Amendment right to talk and to educate people on the law, I think trumps any. It's not like I'm saying I have a case coming up and I want you to nullify in that particular case, or here are the facts of a case that I'm bringing shortly and I want you to nullify in that. That's not why I bring it up, and that's not what I'm doing. I'm bringing it up to let the public know about an important right that's been buried and hidden from you through the history of the legal system, and that you should know about, and that you should choose to exercise if you feel that the law is unfair or wrong. And I don't see a problem with it. But, hey, they'll do with me what they want. Dan, you're on WHP 580 with Carl Rominger. What's going on?
Yeah, I just wanted to make a comment about the NSA scanning. For those that thought that what they heard was ridiculous, I guess the new common logic is you don't even own your phone calls. The phone company owns the lines, and you just basically rent them. So they actually own all that data. I was surprised to find out not that long ago when I actually called my phone company to try and get a copy of my phone records. Now, these weren't cell phones; these were landline records. They told me I had to subpoena my own records.
Right.
And I was dumbfounded because I'm paying them the bill every month, and I said, well, I just wanted a list of the calls because there was some dispute about a family member's call, and they said, well, the only way you can get those is if you subpoena them. And it seemed like you'd have to go through a district justice and then actually have a reason to ask for my own records and everything. It was like, so it's for them to make the assertion that they own it. I guess they actually do. The courts have already seemed to have affirmed the fact that you don't even own your own records.
Let's talk about that, though. It's called an expectation of privacy, okay? So the Fourth Amendment talks about unreasonable searches and seizures, and the courts have said that applies where a reasonable person would have an expectation of privacy. So I expect that if I'm going to call my mistress, right, that AT&T is not going to call my wife up and say, he's calling his mistress again. That's not part of the bargain. In other words, we expect some level, so I'll go more mundane than that. If I call my doctor's office, I don't expect that AT&T is going to call up somebody, my life insurance company, and say, hey, by the way, he just called his doctor again, right?
Right.
Nor do I think that they're going to give those people ready access to it. And so while it's true that the phone company has a lot of data and the employees of the phone company have access to that data, and it's possible that some of that data is going to be aggregated and shared different ways, it doesn't mean that I still don't have a reasonable expectation of privacy. So I'll give you another one. If I'm sitting in your living room talking to you, right, I probably don't believe that you are simultaneously recording it and broadcasting it on the internet, okay?
Mm-hmm.
Or, if I'm in my bedroom with a cute Russian girl, I wouldn't think the whole high school's watching it, whatever, this expectation of privacy. So the question is, once I have an expectation of privacy, what is a reasonable intrusion on it? And warrantless intrusions are per se unreasonable, okay? Mm-hmm. And so you've got to come up with that. So I come back to the theory that don't let the government fool you. They're trying to shift the Fourth Amendment again. They're trying to basically say, well, once you've shared it with anybody, you've lost any expectation of privacy in it, so it's no big deal. And again, if I sent you a picture of my son, let's say, I say, here's a picture of my son at Father's Day, and I sent it to you, I don't think I expect you to then photocopy it and send it to 1,000 other people. In other words, there's still a certain expectation of privacy, even though I've shared something or made it public to a very limited extent. And so anyhow, I just want to be careful.
I thoroughly agree with you. I thoroughly agree.
Yeah, and I'm not lecturing you. This is our just talking out.
It is an intrusion into our Fourth Amendment. But I at the same point, if you would, for those that think it's far-fetched for the phone company to say that they own those calls and their records, they already are acting in that regard. When you ask for your own records from a landline phone company and they tell you as the customer, I mean, even you had a PIN or anything like that, they will make you subpoena your own records.
Isn't that interesting?
I know it is. It's ridiculous, and all you want to do. And in some cases now, they'll give you automatically, they're going to give you the long-distance calls. They're going to list them on there because they're charging it for those. But for a local call that is not listed on a regular landline phone bill, right, they will make you subpoena to get those records.
And it's interesting, isn't it? And so I agree with you. I just want to point out, I just want to keep reminding everybody, don't let them shift it. The Fourth Amendment got shifted once before. When the original Constitution was written and the courts were originally interpreting the Fourth Amendment, it was only you could only get a warrant, okay? You could only get a warrant to get the fruits of a crime, not evidence of a crime. Now they've changed it to giving law enforcement a warrant, not because they think I have anything criminal in my possession, but simply because they may be able to gather some evidence will help prove some prior criminal conduct.
Now, Carl, can I ask you one quick question? And if you have to take it over the break, that's fine. But if you're, I know you in this state, you're not supposed to record somebody if they don't know they're being recorded. Right. But if you're secretly recording somebody and they're actually committing a crime, and then they testify, that they haven't committed such a crime, would you be able to admit that as evidence to prove that, hey, under oath, they lied, they perjured themselves?
Generally speaking, it's interesting. Unconstitutionally collected evidence can still be used for rebuttal and impeachment, okay?
Okay.
But Pennsylvania wiretap law has statutory restrictions on the use of the evidence, which the courts have held that make it absolutely unusable.
Okay.
So that's not even a constitutional question. That's an evidentiary question based on state statute. And so there was a case.
Well, what if it went to a federal court?
That's an interesting question. What would the federal court do with it? The short answer is I don't know. I don't know if they would honor the Pennsylvania prohibition or not, because theoretically they're supposed to follow substantive law of the jurisdiction.
Okay.
But what if you're being prosecuted in a different jurisdiction and the evidence is being brought in tangentially? I don't know the answer. I can think of a case where the government somebody illegally taped somebody, okay, confessing to a crime. And then the government took the victim of the crime and played the tape for them to refresh their recollection. And then the defense argued that they couldn't adequately cross-examine that person any longer because now that their recollection had been refreshed by the police with this inadmissible, unusable tape, they would be put in the untenable position of trying to admit something that was inadmissible, for purposes of adequate cross-examination. That therefore, because they couldn't adequately cross-examine without breaking the law, basically.
Can I do a Durgan? What are you talking about?
Right.
Bro?
Right. So they threw out the evidence. So it was really clever. Really clever argument by the defense, but yeah, a little esoteric. But yeah, so those recordings are dangerous. And I can't tell you, I mean, how many times does a lawyer have somebody show up in their office? Well, I can prove he's lying about the custody thing. I have. And you're like, whoa. I hope you didn't going to say you taped him without him knowing, because that would be a felony. And of course, if you did, I couldn't tell you to destroy the tape because I can't counsel you to destroy the evidence of your crime. So hopefully that's not what happened.
Well, thanks, Carl.
All right, brother. Thank you. 540-0580. We'll get back from the break. Let's get some legal questions here. Oh, we're back. Carl Rominger here, 540-0580. If you have a legal question, want to talk about divorce, your neighbor's tree, I don't know, something about the Fish and Game Code, whatever you guys want to talk about, just jump on the air here, 540-0580. AJ, what's going on?
Hey, Carl, how are you?
Good.
Hey, Carl, I just had a question about privacy and medical records, basically, as it relates to the Second Amendment, you know, with Andrew Cuomo, what he's trying to do up in New York. Basically, if I go to the doctor and they write stuff down, where does it go, and does it go into some big database that Kathleen Sebelius has?
We don't know. And what I mean by that is they were in New York, right? They're making people report you to some kind of database if you meet certain criterion. And you may not even know you've been reported out on it. Now, your privacy in your medical records, while presumed, isn't and hasn't always been absolute. So, for instance, my doctor has to tell PennDOT about certain things about me. So if I go in to see the doc and there's some certain symptom I have or some certain diagnosis, or if I tell him or her about something that happened or might have happened, they may feel compelled by statute to tell PennDOT. Also, medical privacy doesn't apply to a child where there's suspected abuse, right? So we know that the medical privacy is not absolute. And so, again, it's a statutory framework that all this happens. I'm not sure where you draw the line because, you know, when it came to the constitutionality of banning abortion, right, the courts found sort of a privacy interest in your own body and for women. So I'm not sure how that would extend completely to the medical field. I suspect if there was a law passed that said all your medical data shall be shared openly, you may be able to dispute the constitutionality of that, right?
Can you request your own medical records?
Oh, yeah, you can absolutely get your own medical records.
Can you request that they be deleted?
That I don't know the answer to. I really don't. You know what we really should do? We need to get somebody in here. And so I'll put the word out here on the street. Somebody who's an expert on medical privacy.
My concern, Carl, is not so much today, but 10 years from now or 15 years from now when they start changing the rules after the fact.
Right. Well, but see, that's always the issue. See, everybody always says, well, Carl, why are you upset about that? All they want to do is this or all they're going to do is that. And I'm always like, what's like the camel's nose, you know?
Yeah, because, I mean, if I go to a doctor with a stress headache, and, you know, they write it down, you know, 10 years from now, I don't want to be in a gotcha mode.
Right. Well, that's the problem. That's the problem. The rules change, the definitions change, and all that data is going to be aggregated and maybe someday used against you. But I think it would be interesting to get a medical privacy person in here to sort of give us a better framework of how things really work right now. So I'll work on that. I'll put Shane on finding us somebody.
Thank you.
All right, man. 540-0580. Get your legal questions answered. Jack, you're back.
Hey, Carl, how are you?
Good.
Hey, I have a question for you on that juror nullification.
Yes.
Let's suppose that the jury decides that they really don't think the guy did it, but they want to convict him because of his race. Isn't that juror nullification?
That's the opposite. That's the opposite side of nullification, where they convict somebody when they're not supposed to. Except that's not really nullification. Okay.
But can't they say the law ought to be that someone of that race can't do something with, say, someone of a different race, and therefore we should convict them?
Yeah, they could. They could theoretically.
And from your standpoint as a lawyer, how can you know if the jury, if you don't know what law the jury is going to use, how can you argue your case to them?
Well, that's always an issue as well.
So you still think it's a good idea?
Oh, I think jury nullification is generally a good idea, yeah.
Okay.
Because there's a second safety valve, and it's called the judge, right? And if he hasn't been sleeping and he's paying attention to the case, and the government hasn't proved their case, right? And a jury tries to convict somebody who's clearly innocent because of a racist reason, well, the judge is there as a safety valve.
Well, suppose it's the other way around, like what happened in the South years ago, where if a white man committed a crime against a black man, they go to trial and they'd always get acquitted.
Right, and that's
regardless of what the law was.
Right. But do you think we still need affirmative action in this country, or are we race neutral enough now?
Well, I don't know that we need affirmative action, but I know we're not race neutral either.
Right, and that's an issue. So I understand exactly what you're saying, is the judge might be racist too. On the other hand, if the judge is racist, the jury's probably not acquitting you.
If there's an acquittal and there's double jeopardy, then there's certainly not going to be any justice.
Well, if there's an acquittal of somebody who's guilty?
Yeah, let's say somebody's clearly guilty,
mm-hmm.
but the jury acquits on the basis of race.
Right.
And it's only going to be 10, 15 years till white people in this country are minorities.
We'd rather a lot of guilty people go free than one innocent person go to jail, right?
Okay. I'm just curious what your position was on that.
I know, I understand, and that's always the number one counter argument is the potential for the interjection of racism. And I think that's where the judge becomes a safety valve in that direction.
Okay.
But if you believe that the judge could be racist, then you have to understand that the judge could do a lot better job of screwing a defendant on race than they would have to by simply refusing to nullify, by simply just making sure that every evidentiary ruling goes against the defendant, and also by making sure that when he or she instructs the jury that they do so in a way that's designed to pretty much tell the jury, find this guy guilty.
Good thought.
All right, my friend. Good. Thank you very much. Yeah, I mean, that's the joke. When you go to court, the judge can hang you right off the bat, or he can push the jury in the direction. They can't absolutely control a jury, but when it comes to evidentiary rulings and control of decorum of the courtroom, we've certainly found ourselves in positions as lawyers where nothing's going our way, so to speak, and one starts to question the impartiality of the court. Although a lot of times that's just in the lawyer's head, because the lawyer is starting to lose a lot of rulings and start thinking, well, this is fixed. And of course, then the client's in your ear going, it's a kangaroo court. What do I do? The point is, though, is judges do have a strong influence on the juries. And when you ask the jury afterwards, they're always wanting to know what the judge thinks or which way they thought the judge was leaning, because they think that tells them something. So good judges are very careful to point out to the jury that they're not. But I've had one or two really bad experiences where judges have completely misstated the law to a jury and done it in a way that I thought was terribly prejudicial to a client. And the problem is getting effective review of it's hard, because a lot of it has to do with the way things are said and the inflection at the time and the overall circumstances of the courtroom. And that never gets reflected on a transcript. In fact, when you read a transcript, and this happens a lot, I get clients that insist that the transcript has been changed. And I go, it's not been changed. Your problem is simply this. Human communication, much of what we do is done with our hands, with our inflection, with our tone, with our eyes, with our stance, whether we rise or sit, whether we wave a right hand or both hands, whether we make figures in the air. And so if you actually start to transcribe just a regular conversation, or even transcribe this show, like a conversation between me and one of the callers, and you read it, there's less information in there. And things that you're sure you said, you may have said with your hands, with your eyes, with your feet, aren't going to appear on the paper. And as a result, the transcript wasn't changed. It's just that the transcript does not reflect the information that was exchanged in the courtroom. And that's an important point, which is why lawyers sometimes will say, let the record reflect that the witness did this, or let the record reflect that the witness did that. And those are techniques and tools to try to take that that dry transcript and add to it the information. But here's the problem. You never find in the transcript exactly what you expected to find, because some of what you recall is that nonverbal communication. So don't blame the court reporter. The judge did not fix the transcript. Nobody's cooking the books. That's just human recollection versus what's actually taken down. And so that's important. It's very important. That's why, of course, getting effective appellate review quite often is difficult, because a certain percentage of that information fades and can never be captured. It's surprising in this day and age that we don't just simply tape the proceedings, so that instead of just reading the transcript, the court above could actually watch what happened. I mean, what kind of a novel idea would that be? We've only had video for how many years now, and courts probably still are reluctant to use it as a means of review. But it would probably be a more effective way of looking at things in the future. So it'd be interesting to see how that plays out. When we get back from the break, we'll talk with Scott. 540-0580. See you in a minute. Oh, welcome back. Carl Rominger here, 540-0580. Scott, what did you want to talk about?
Hey, Carl, how are you doing today?
Good.
Hey, thanks for the program. I think you're doing this community a great service. But there's a strange phenomenon going on right now, and it's being done with computers, maybe even cell phones. So this week, been woken up at odd hours of the day, early, by phone calls from Michigan. So today, I got mad enough to call the number back. No answer. Called them back. Left a really nasty message. Called him back a third time, and I was like, I get to talk to a human. And it's like, sounds like a 90-year-old man.
Mm-hmm.
And I was like, okay. And he goes, I've been getting calls like this all week, and I have this bundle package with Verizon, and I said, I know what's going on. Because the same thing happened to me last year, and it took almost a year for it to stop. Unscrupulous people using computers are just pulling numbers randomly out of the air, putting it in their computer and dialing out, and then doing their little scam or whatever it is they're trying to do. And then these innocent people are getting mad. PO'd people call them back, but see, there's no trace to who punched in that number. This is happening more and more and more. And as soon as I heard this guy, I was like, well, I can tell you're not the guy who's harassing me, because you could tell this guy had to be 90 years old.
Right.
But it's going on, and people need to be aware that if you're getting phone calls... It
might not be from who you think you're getting it from.
Exactly. And if people are saying, I'm returning your phone call, and you didn't call them, and it's from out of state, it's called spoofing. And it took almost a year before they stopped using my phone number, because this happened to me. I was getting calls from all over the country at all hours of the day saying, I'm returning your phone call, blah, 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 a lot of obscenities. But after about a year, it stopped, and they moved on and started using someone else's number. So people need to be aware that this is going on. I don't know what kind of recourse there could be for it, because in this high-tech world, what do? You can't do anything.
Right.
But I just thought I'd let you and everyone else be aware that if you have circumstances like this going on, that this is what's happening. It's called spoofing. Just be aware.
Got it. Thank you very much.
Thanks, Carl.
All right, brother.
See you.
540-0580. Ethan, what do you want to talk about? Ethan.
Hello?
Yep, you're on the air, brother.
Oh, sorry. Not Ethan. Name's DJ.
Oh.
Hey, real quick, thanks for taking the call, Carl. I've got a question about what you were talking about before the break, about how court transcripts really don't tell the whole story, and that makes absolute perfect sense. And I'll take your answer off the air, but why don't the courts use some type of video technology instead of just relying fully on transcripts?
All right, we want to take that off the air. Well, here's the answer. I don't know, and that's kind of what I'm ruminating about is this day and age, well, first of all, for a lot of courts, it would require them to allow cameras in the courtroom. And heaven forbid that the judge be balding or that the lawyers might act a little differently or whatever the theory is on why we can't have cameras in the courtroom. But it solves a lot of problems. Now, for Pennsylvania, for instance, having been involved in the Sandusky trial, it was fascinating to the national press to deal with a courthouse that is so anti-camera, generally speaking. In Florida, they actually create pool cameras and just push the video out. So that's why you see so many Florida trials covered. Florida also does something else very interesting, which is they release all the documents and discovery to the public. They become part of the public file. They don't let the prosecutors hide the materials the way they do in a lot of other states, ours included. And so as a result, it makes for visually interesting trials. But on a side, the more important note is why not, if you're not going to allow the public to see the video, why not simply make video of the witnesses and preserve the record that way? That way, if there's an audio and visual recording that can be reviewed later. And why we don't do that, I don't understand, except maybe judges don't want to have to watch videos. Maybe they'd rather sit in their armchairs or at their coffee tables or wherever judges read transcripts at night in the morning and go that route as opposed to having to watch the equivalent of my grandmother's home videos. Like, oh, Grandma, you're getting the video out now. Oh, boy, the family's so excited to sit here and watch for 2 hours as lame things happen. And can you imagine watching 20 hours of video? Well, the answer is that's your job. You have to read 20 hours of transcripts or watch 20 hours of video. Or maybe preserve both just so that the lawyers could say, Judge, I know you like to read transcripts, but I'm going to excerpt, 20 seconds of video here and 30 seconds of video there and embed them in my brief so that you can see this. We have the technology to do it. Why courts won't do it, nobody knows. Maybe somebody can tell me, but I don't know. Ted, you're on the air. Hey, Ted.
Hi, Carl. I just have a question. Who's supposed to pay school taxes? Is it homeowners or is it everybody?
Well, it's anybody that owns land.
Anybody that owns land. Okay, well, then here's my question. I got my concealed carry permit.
Mm-hmm.
And as soon as I got that, all of a sudden now I don't own any land, and I'm being told that I owe school taxes.
I don't know. Who's telling you that? What property are they taxing you on?
It doesn't say that. And the thing is I have a friend of mine that he said the same thing. As soon as he got his concealed carry permit, all of a sudden he has to pay school taxes.
What kind of school tax? Is it a tax bill from the district?
It's yes.
I mean, what's it say?
It's very vague. And I tried to call the phone number they gave me, and there's no answer. It just says leave a message.
I think you're getting some kind of scam, my friend. School tax is based on your school tax and your county tax are based on your property that you own.
Okay, so unless you're a homeowner, you do not have to pay school tax, even if you have.
Well, what school district do you live in?
Southampton.
Did you call them and ask them if they sent you a bill?
No. I just recently got this. I just got my concealed carry permit about 3 months ago, and then all of a sudden I get this tax.
I don't think there's any connection whatsoever. I think you and your friend live in the same area, and they're just scamming you.
Okay, that's good to know. Thank you.
All right, you better. Yeah, all right. Larry, you're on WHP 580. Hey, Larry.
Hello. Hey, how you doing?
Good.
I was listening to your radio. I'm standing here in my garage taking the tint off my windows. The tint came right off, but the glue is hard.
Oh, is there glue on there?
Underneath the tint, yeah.
Oh, see, mine peeled right off.
Per your advice, I'm taking it off.
Well, Larry, what did I tell you about the tint? I said pretty much any aftermarket tint's illegal, and the problem is it just gives the police a pretext to fish, right? And we don't want to give the government any more advantages than they already have.
So I'm taking your advice. I just wanted to give you a ring and say I'm working on it.
All right, brother. Thank you.
Yep. See ya.
That's the kind of advice I dispense in places like the Gingerbread Man from time to time. I got you guys asked that question a few times recently. How much tint is legal? And the answer is almost none. The government, by the way, where does the tint regulation come from? come on, all you good people out there. Well, the government just wants us to be able to see. The government just wants... No, the government wants to be able to see what you're doing in your car. That's what the tint regulation is all about. That's been known forever. The only purpose in restricting tint is so that Officer Smith and Agent Bill and all the other government actors may peer into your car and see what it is that you are doing. Nothing scares the police more than pulling over a car that's fully tinted windshield and sides, right? Because you might have your Uzi leveled at them or whatever other thing they fear you're doing. Or you might have time to make furtive movements to hide your drugs that they won't be able to see. That's why if you want the most privacy, I recommend a van with no windows up high so that they just have those little tiny corner windows in the windshield to see what you're up to. Don't give them any extra viewing space. So, yeah, almost all tint you see is illegal. Fortunately, most officers aren't out hunting the tint all the time. And, of course, if you watch the DUI stop video that I have on Facebook, you can hear them referencing something about my tint as well. Actually, not the tint on the car in question, but the tint on the last car that they'd pulled me over. I guess they were still smarting from the fact that I wouldn't roll my windows up to let them test the tint. Actually, we should have asked Braxton Diddy yesterday about tint and, you know, why police officers key in on pulling over illegal tint. I think a lot of times, again, it's the sort of advantage of just getting a free pass. In other words, I see a car go by, it has tinted windows, I'm going to just pull them over and see what's going on in there because I can. By the way, what am I going to do today? I'm going to watch a little of this U.S. Open, right? Little rain delay. People were claiming that the soft conditions were going to cause these guys to just tear this short Marion course right up. I guess that's proving to be wrong. These scores are not exactly phenomenal. In fact, they're more in the open range, if anything else. All right, guys, have a great weekend. Enjoy. I'll be here next week. Bye-bye.